Morning, everyone, again. Welcome to the Joint Select Committee established to consider the Cybercrime Bill. I am the chairman of the committee, Faris Al-Rawi, and present with us are the other members of the committee who I would invite to introduce themselves for the benefit of those in attendance, beginning with Member Huggins to my far right.
Good morning, everyone. Ronald Huggins, member.
Good morning, Clarence Rambarat, member.
Good morning, Paul Richards, member.
Good morning, Wade Mark, member.
A very good morning, Fitzgerald Hines, member.
Good morning, Rudal Munilal, member.
Good morning, Edmund Dillon, member.
And good morning, Melissa Ramkisoon, member.
May I invite the representatives from TSTT and from Digicel, respectively, to introduce themselves, beginning with Digicel.
Good morning, Ryan Lightwood from Digicel, fraud analyst in the Business Risk Department.
Good morning, Candice Coombs from Digicel, legal and regulatory advisor.
Good morning, I'm Laura Dowridge Phillips, regional lifestyle editor of Loop Trend Media, Department of Digicel.
Good morning, Anil Ramdan, IT security analyst, IT.
Good morning, Charles Carter, EVP Legal Regulatory Corporate Secretary, TSTT.
Good morning, I am Gail Alex Solomon, Senior Manager of Legal and Compliance, TSTT.
Good morning, Brent Holton, Senior Manager, Security and Operational Risk, TSTT.
Good morning, Roger Richards, Chief Technology and Information Officer, TSTT.
Good morning, everyone, and thank you sincerely for making yourselves available to assist the committee in its deliberations. We're very interested in amplifying our understanding and our exploration of issues which have arisen in this bill. We have received written submissions on the bill, and we feel it important as a part of the work of this committee that we make ourselves available to understand further issues which may present from the industry players, in particular from both entities. You function in multiple roles as service providers, as users, as corporate citizens involved in this particular matrix. The bill, as you are well aware, encompasses not only the concept of journalism, but also to the concept of data management and data security. And therefore, you provide a very essential understanding to the less appreciated aspects of the bill. In those circumstances, we'd be very grateful not only to hear your amplification on the issues that you've already raised in written submissions, but also any issues that you wish the committee to consider. May I invite Digicel to begin with an opening statement if you have one. You are free to indicate what areas you wish to focus upon, and then we will turn over to TSTT for its turn. We'll then open the forum to members of the committee to ask any questions or to receive any questions that you may have. And therefore, we can explore the issues that are set out before us now and in your written submissions. May I ask Team Leader for Digicel to begin?
Hi, morning. We don't have a opening statement per se, but I would just like to say that we find the penalties generally to be a bit draconian, and that's our general stance on it right now. The different departments will go through their specific areas as we delve into the act itself. Thank you.
Sorry, thank you, Ms. Coombs. We've received from Digicel identification of just a few short sections. Section 23, Section 24B, and Section 28. We're adding on to those observations which we've received the identification of the penalties which are prescribed in the bill. Could I ask that you address us on the issues that you've already raised, and then when you get to your sanctions in the bill, that you identify your view on the criminality that is proposed in terms of treatment?
I would actually ask my friend from IT to address that section 23 as it relates to his area.
As you please.
Morning, everyone. Morning, Mr. Chairman. Regards to section 23, where it says Internet Service Provider with a domain name server is storing. We don't have a domain name storing anything for the public. Our domain is strictly for internal use only.
May I ask you, for the benefit of those who don't understand, in the general listening public, to perhaps expand upon what you mean to communicate by that statement? I confess that I do understand this area fairly well, as I have a master's in information technology, but I fear that most other people may not catch what you're saying. Could I ask your indulgence in explaining your point of view?
Sure. For example, a domain is, for example, is digicelgroup.com. We don't have a domain that is storing public information for the public. It's strictly for internal use only.
May I ask then whether you provide relay services for the hosting of domain names?
Not that I'm aware of.
Not that you're aware of?
No.
So from your perspective as a provider, you, within the context of Section 23, and for the benefit of the listening public, I'll read Section 23 so it's put into context. If a magistrate is satisfied on the basis of information on oath by a police officer that an internet service provider or any other entity with a domain name server is storing, transmitting, or providing access to information in contravention of this act or any other written law, the magistrate may order the internet service provider or other entity with a domain name server to remove or disable access to the information. The submission received from Digicel on Section 23 reads as follows. The wording of this section is quite broad and allows a magistrate to compel an internet service provider to remove or disable access to a site on the basis of an oath by a police officer. Given the draconian consequences at hand, there should be a higher standard of proof and more robust evidentiary requirements before a magistrate can issue a directive under this section. Further, the ISP should be given an opportunity to be heard on the implications of such a potential directive and to challenge any decision made, as its entire customer base can be affected. Additionally, there should be dialogue with ISPs to determine the feasibility of compliance with a directive under this section, as the processes involved may require significant resources and the technology to do so may either be unavailable or extremely costly. Having the benefit of your submission in writing on Section 23, but having heard you orally, it appears that this morning Section 23, from Digicel's perspective alone, does not bite because you do not host domain names. Could you explain, therefore, your submission insofar as it doesn't relate to you?
I think that considering the IT perspective that was just given, we'd probably like to not include this comment as a submission.
Much obliged. May I ask a question, however? If it is that this clause related simply to an entity which stores, transmits, or provides access, in Digicel's construct as an ISP, could you explain to us, or perhaps confirm, whether you in fact store, transmit, or provide access to information through your network?
From an IT perspective, we supply data to the internet, which is we don't store any servers for internet use.
You access cloud basis. How do you transmit from point A through your host network?
That would be more of a technical question, but no one's in that room, in this room right now for that question.
Your on-site storage for whatever data passes or your transmission of data, I would assume is both locally constructed and internationally constructed. Is that correct?
I'm not sure. Like I said, that's more a technical question, and no technical business here for that.
Perhaps I could ask your legal, do you have licensing arrangements for transmission of data to other jurisdictions?
I believe that we do. However, we could take that question back and clarify and make another written submission if that's okay.
Sure, as you please. May I ask then that we turn to your submission on Section 24B? Section 24 of the bill reads as follows. If a magistrate is satisfied on the basis of information on oath by a police officer that computer data, a printout, or other information is reasonably required for the purpose of a criminal investigation or criminal proceedings, the magistrate may order a person in Trinidad and Tobago who is in control of an apparatus to produce from the apparatus computer data or a printout or other intelligible output of the computer data, or B, an internet service provider in Trinidad and Tobago to produce information about a person who subscribes to or otherwise uses his service. The submission from Digicel is that the magistrate may order an ISP to produce information about a person who subscribes to or otherwise uses its service. The type of information that can be required of an ISP under this subsection should be exhaustively listed. It is worth noting that there may be limits to what an ISP can provide in this regard. While information may be retained about account holders themselves, ISPs would not necessarily be able to identify users who are not account holders. Could you give us a little understanding as to, firstly, what you wish to be exhaustively listed? And then secondly, could you distinguish the point of view between account holders and persons who are not account holders as it relates to transmission on your network in the capacity as an ISP?
I can speak to the first issue, which is the information about a person who subscribes to or otherwise uses the service. I think that the term information is very broad, so I think we need to specify exactly what kind of information is to be captured in that section. For example, name, address, date of birth, that type of thing. So we need to have a more streamlined process onto exactly what type of information we'd be required to provide. In terms of the transmission of data and the account holders versus persons who aren't account holders, I would say that if you subscribe to the network, depending on what type of service you subscribe to, we would capture information such as your name, certain identification points, and you would be registered on the system as an account holder. So let's say, for example, you are part of a family and you have different persons who are accessing different devices under your account. We won't be able to tell who those persons are because we have you named as the account holder. I'm not sure if Anil wants to jump in here to clarify a bit more on that point.
Agreed with Candice as well. Also, persons own hotels and so on would be under the same consequences as well.
Is anyone permitted to use your service in circumstances where they are not account holders or under a package of account holders?
Can you be a bit more specific?
So, your identification so far is that points of information relative to account holders will be recorded if you are a subscriber to a service that you provide. Is there, under that arrangement, an access for persons to use your services other than as account holders?
Well, as Anil described, in a situation where we provide services to businesses, the members who use the service may not necessarily be account holders, but they would be under a corporate type package. So there would be one point person who's the representative for that company, and there'd be a number of devices under that person or a number of laptops depending on the scenario. So those particular persons won't be account holders, but there would be one person who's named as the account holder.
Before I open the floor up, if I could just expand upon my inquiry. Would you, for instance, host or record information, including IP addresses for individual devices? So whilst you may have an umbrella service, say to a corporate client, a hotel, a business with 50 users, would you have amongst that class identification capability as it relates, for instance, to your IP address, which is an individual and unique item from desk to desk or laptop to laptop or device to device? Is that information hosted by you for any user of your service?
I actually can't answer that question. I'm not sure if Anil might be able to assist here, because we have a specific department for IP, and that member is not here today, so maybe he can help us.
Sure, please.
We'll have to confirm and get back to you on this in writing.
Okay. May I see that Member Munilal and that Member Hines also have some questions?
Yeah. In an attempt to understand this, you are saying that you will have the record of the account holder, and we now understand by that you mean, for example, a hotel. They have an account with you and they have thousands of guests over time, and guests are allowed access to their service or to the service provided by you through the hotel. And in that regard, you will only have information about the hotel, the account holder, and not about the various guests. And that is where the question from the chairman came, whether in the use of that service, so I stick my laptop into the service provided in my room at the hotel, does it record my own unique identification as the user, which is a point that you say you have to get back to us on. Apart from that example of the hotel, if someone without authority used a service provided to one of your account holders, then of course that account holder under this general law will not be liable for anything because he did not knowingly or wittingly cause someone to do that. So my mind ran on the situation, for example, with a driver's permit. A person with a driver's permit, or a person who owns a vehicle, while someone may, without authority, take that vehicle and drive off and create a problem, or I may lend the vehicle to someone and they cause some issue, I have a duty to notify the police or the licensing authority of such illegal use or my authorized use, in which case I have a duty to notify the licensing office or the police or the court ultimately who used the vehicle at the relevant time. That is the kind of thought process that I'm having here, and that's the kind of obligation we want to ensure.
I'm trying to understand your question, member.
Well, I'm trying to understand the submission made by the service provider that there would be occasions when they may not have the information to share under their obligations in this law because that person who would have used it may not be an account holder. Am I, yes? So that is my understanding of it. And this society wants to be sure that the person who did it must be able to be identified. And whether your records, even for persons in the hotel example, will be able to identify that through an IP address or something like that.
If I may, in terms of the hotel, let me just clarify, when account holder or the person who's in charge of that account signs up for a package, the members who use the hotel or the guests who use the hotel usually use the hotel through Wi-Fi. So I would have to get back to you and to the committee in terms of how Wi-Fi users are captured and if their IP addresses are recorded, because I can't speak to that at the moment.
Thank you.
Member? Thank you very much. Just two questions, and one really just to clarify a matter earlier. Under Section 23, the issue that Mr. Ramdan, I think, raises that, is it that I understand you clearly that the difficulty there is that you don't have a domain name server?
We don't host domain names.
So if the law, just hypothetically, we put here domain name server or internet service provider, that captures everyone? Because you're an internet service provider. Right, so that captures it. Just hypothetically, because I just wanted to be clear that that was the issue that you touched earlier. But it's a matter that the committee could look at later. Thank you. 24, to get back to this issue, and I was going to say that in the hotel, of course, as a guest, is a Wi-Fi you connect to, but for the user, as opposed to the service provider, for the user, they should have adequate record of someone accessing a service through Wi-Fi, because you generally have to comply with some information in terms of either your room number, your surname, or something. And that connects to another body of information that you are a guest at the hotel. The same may apply at a place of work, because clearly you'll have an account holder, but you could have hundreds of users and so on. But it's not an automatic process. So that you're saying that this, is it that you're saying that this is, to use your term, draconian somewhat, but you cannot identify users? Because you can identify account holders, but you cannot identify users. That is your submission here, is it?
Submission. I actually, I didn't refer to this part of the bill as being draconian. I was referring to the penalties. But that is our submission, that you could identify the account holders, but not necessarily all the users.
Okay, so you're saying that a challenge we may have as a committee working with you is that we can craft something that capture users, because we may be after a user for some nefarious activity. Okay, I understand that. Could I just, on one matter again, you said that the issue of information was a troubling issue, because you have to produce information, or the person who subscribes to otherwise. But the information you are detailing, whether you have all or you have some, you can produce information. So it may not be necessary, I'm asking you, to have a list of information, because you provide what you have. If you have name, address, telephone number, date of birth, you can provide. If you don't have nationality, you don't have marital status or something, you can't provide. So I wanted to ask you whether it's really necessary to put in law to suggest an exhaustive list, because there's a principle that you provide what you have.
Remember, you have taken the words out of my mouth. I was just going to recast this way. Would we be satisfying your written submission, the concerns in your written submissions, if we were to point out the law doesn't ask you to keep information of a particular type? What the law is asking you in these sections is to produce that which you have. You can't produce something which you don't have. It is simply that you produce. So for instance, Section 23 is an entity with a domain server. So if you don't have a domain server, it doesn't apply to you. Hence, I accept that you've retreated from that submission. But in Section 24, the obligation is simply to provide that which you have. There is nothing that compels you in this law to maintain specific types of information which you don't have. That will be confined to your licensing and factual arrangements as to what you keep or don't keep. In fact, that finds itself under data protection laws, where you must keep certain types of information in certain ways, but those laws are not yet fully proclaimed in Trinidad and Tobago. Is that mischief what you were driving at in the obligation that you've set out in your submissions? The fact that somehow you were potentially being asked to keep something which you didn't have?
Actually, it's not necessarily to keep something that we don't have, it's to produce the information. And as you rightly said, we can't produce information that we don't have. So if we can produce the information that is available to us with regards to that section, and that should be fine.
What's part of the question also, and forgive me for introducing the concept here, the concept of a quote-unquote strict liability. In other words then, was the mischief in your mind that a court order would say, produce X, and that you would then turn around and say, well, I don't have X? Was there some understanding in your camp or concern that you may find yourself in contempt of a court order for something which you physically don't have? Was that part of it?
I don't believe that was part of it. I think we just needed clarification on what type of information we were required to produce.
Thank you. Yes, please.
Could I just one follow-up question, just again for our information, because as the chairman said to us, the data protection legislation is not fully enforced. As it is now, do you keep information on your users or your account holders? Do you keep information, and for how long do you keep information? Hypothetically, again, I am an account holder with Digicel, but I ceased being so in 2015 or 2016. Do you keep the information that this legislation would want you to have?
We do keep information on account holders. I can't say for how long, but I believe it's stipulated either in the concession document or the consumer rights and obligations policy. So I can revert and submit it right on there.
Thank you. Just for information purposes again, basically, because I think at least there should be some minimum information that should be maintained. What sort of information do we keep at this time?
I can't answer that question. I'm not sure if one of my friends might be able to assist here.
Well, we have the benefit of TATT sitting in the audience, who can perhaps clarify from a regulatory point of view that which you're obliged to maintain. So we can receive assistance. So what we would ask you to do is to just provide us with your information management policy by way of a further submission. If you could just indicate to us what your data retention policy is and its parameters, it would certainly be very useful for our consideration. Yeah, thank you.
Much obliged.
May I, Mr. Chair? Mrs. Combs, I just wanted to ask, when a user applies to Digicel for installation of some telecommunication apparatus, you enter into an agreement with that particular user?
Yes, we do.
Does that have privacy provisions, and how would that impact on what we are discussing here? Privacy rights of the individual, and how would the provider address those issues in the context of these provisions of the law?
Okay, so when you subscribe to the service, depending on the type of service that you subscribe to, we have certain terms and conditions that govern the specific types of services. And it is an agreement, and there is a confidentiality clause in there. However, I believe depending on what we're asked, we may make certain amendments or try to facilitate as best as we can without breaching any data privacy. So we'd need to discuss how we'd approach that particular situation in terms of what we need to submit, in terms of what the government would need to get the bill out in terms of data privacy.
Is in section 28, you said that any cost borne by the ISP, that is the internet service provider, in order to comply with the section, should be recoverable by the ISP, dealing with the whole question about remote forensic tool. What you had in mind here exactly, or could you explain that to us? Who has to pay the ISP provider? Is it the state you're asking to pay? I'm not too clear on this.
I actually, with reference to this section, I wanted a bit of clarification on exactly what the remote forensic tool is meant to do. How is it to be devised? What does it entail? That level of detail is not included in the bill. So, and I'm sure in producing the forensic tool, it would incur cost. So I guess the issue here is clarification on how this whole process is meant to work.
Thank you, Mr. Chairman.
Yes, please.
Thank you. Good morning again.
And I note that Member Rambarat has been holding his patience for a question. He can follow just after you, please.
Yeah, for the clarity of myself and the public, I'm sure. I know we're trying to balance law enforcement, judicial process, and privacy and confidentiality issues. Two-part question. We identified your account holders who have contracts with you, and also circumstances where, like hotels, educational institutions, and I guess in some instances, free Wi-Fi zones where you may not have accounts. Those people will not have accounts, but will be able to access your service. Will your confidentiality issues in terms of what data you will get through your process of granting that service through those circumstances still stand? And in those circumstances, for example, educational institutions where people come in and access your free Wi-Fi, or hotels or businesses, does your internal protocol system also capture biodata from those users as different from your contracted users?
I believe your question and the question from Dr. Munilal are quite similar. We would have to revert to the IP team to see what kind of data is captured by Wi-Fi users to be able to give you a proper answer.
Given the global circumstances we've all seen, where I know law enforcement in other jurisdictions have used devices to track a person's location, and that account holder can be tracked through the cell sites and trace where that person is based on their account information. Is your service in keeping with that standard of operation, or would you have to revert to IT people to get information?
We would have to revert as well, because I'm not familiar with that.
All right, and finally in this round, given the fact that your submission indicated that you seem to have a concern about the benchmark regarding, and I'm talking to clause 23 here, section 23, police officer that an internet service provider or any other entity with a domain name, which we can ignore now because you've said you don't have that, for storing, transmitting, and providing access to information in contravention of this act or any other written law, the magistrate may, under the internet service provider or any entity with a domain name, etc. What would be your, as a service provider, comfort level for that particular aspect of it in terms of the benchmark for the service provider providing information for judicial process? It seems that there's a concern there.
So that's a
with
hypothetical.
benchmark. Yeah.
If you were to go into the business of hosting domain names within the confines of Section 23, do you have a general view?
Or even if not,
Yeah.
even if under your present circumstances, what would be your comfort level with the language? In terms of the benchmark for the service provider being comfortable, is it a case-by-case examination? Or is it, would you be comfortable with a particular benchmark established in legislation?
I'll actually have to get back to that question and do a written
And quickly, given that there have been pretty high-profile global cases involving huge companies like Apple and Google with the same issue of data access and customer information, client information, and confidentiality regarding data, I'm sure your company is keeping up to trend with those. What sort of data would the company, and I guess this will go to TSTT also eventually, be comfortable with in terms of the access to data at that level? Is it that typical? What kind of access would you be comfortable with, given the fact that both Google and Apple have one high-profile cases restricting the state from accessing that data? Is your company trending along that thought process for absolute protection of data from customers?
Can you clarify that question?
Google and Apple have both, in recent times, won high-profile cases where the state was seeking to get information for judicial process, which has become quite, a lot of cases have been predicated upon that. Would that be the mindset in terms of your own company's thinking?
I won't be able to give a position on that, but I can review it and get back to you.
Thank you.
Before I turn over to Member Rambarat and then Member Ramkisoon, may I just ask one question? Insofar as you've made an observation under Section 28 that the cost of the ISP in complying with the order should be factored, may I ask how you treat with costs under the Interception of Communication Act, where compellability of evidence may be required of your company?
I'm not quite sure if there are any issues related to equipment or machinery in terms of the Interception of Communications Act. I think it's more of a resource, so I don't think the cost there is a factor. Considering that we don't know the specific details of what's required by the remote forensic tool, I think that's the issue there.
I see. So from a direct cost to intrusion of your operating system, insofar as there may be a technological requirement and interface, you reasonably anticipate that there may be a cost factor to your company, both upon installation and removal. And in those circumstances, you've asked us to consider whether there can be clarification as to who bears the cost where you are carrying out a function as opposed to causing it yourself. That's your submission?
That is my submission.
Understood. Thank you so much. Member Rambarat?
Thank you very much. I want to make two comments. The first thing is that I'm at a severe disadvantage because I really came to ask a few questions. When I looked at your submissions, both TSTT and Digicel, I was very disappointed because I found that they were very narrow. From the first clause in this legislation, this bill, the first to the last, I think it engages TSTT and Digicel fully. Particularly, I came with the public interest in mind and how this will affect your relationship with your customers, and more importantly, your ability to assist your customers who may be affected and would want some recourse under the legislation, particularly the criminal provisions. So when I saw that both of you were very limited and very self-serving, I would say, in the way you have approached the bill, I thought there should have been a more fulsome consideration of both the legal and technical impact of the legislation, not only on you, but on your customers. That's the first point I want to make, because I keep hearing we're not technical here, we're legal. Well, this bill is a combination of technical and legal. And to get to the legal, we have to get past the technical, because your systems, the backbone, belongs to one of you here, both of you, at some stage. And we don't get to the offense unless we establish the conduit for that offense, and the conduit is your infrastructure and your backbone. That's the first thing, and it puts me at a severe disadvantage, because I can't ask some of the questions I wanted to ask in the public interest. And let me give you an example. So it is the narrowness of your submission, the fact that you've seen the bill as 3 or 4 clauses, and I see the bill as a comprehensive bill that from beginning to end impacts either you or your customer base. And the second one is the lack of technical, and let me give you an example. Hypothetically, like Dr. Munilal, if I'm a Digicel customer, right here in Port of Spain, I am on B zone on many occasions. So that I would like to know, because this bill deals with, first, a physical interaction and interference with a computer system. So this you may find that somebody goes without permission onto a computer system. And that is an issue for a simple thing as a password being obtained or a computer being hacked. But generally, the infractions in this bill deals with 2 things in particular. Using an IT backbone, because it's going to be very rare that somebody goes onto a computer and transfers information manually from the computer's memory onto a flash drive and commits an offense. I think in most of the cases, somebody would access a computer. I understand that may be a password issue, and then access further information, which may or may not be an email account owned and provided by one of you, but definitely the information access may be transmitted, and whether it's a TSTT email account or a Yahoo email account, it would be transmitted with the use of either IP provided by you or some interface with your infrastructure. And to establish the chain of events leading to the commission of the offense, we would have to first establish the course of activities, the way in which both the physical and IT infrastructure was used, the ownership of the chain, the contractual relations along the chain, and a number of things before. These are simple in the sense of how it looks when it appears on Facebook, but there's a lot of things happening behind the scene. And your customers, including me, are not aware of it. And it is very important that this committee and the public gets a complete sense of how this very important bill affects the contractual obligations which currently exist, the changes that would have to be made to those contractual obligations, and the entire IT infrastructure chain under the regulation of TATT and owned by TSTT, Digicel, Flow, or one of the other providers. And that is perhaps the only submission I'm making today.
You, Member Rambarat. May I intervene with one question and then pass to Member Ramkisoon? In your click license or a shrink wrap license that you may offer or stand by, do you have cross indemnities in your licenses? In other words, if someone is found to have caused you loss, harm, or damage as a result of criminal action, do you have an indemnity provision in your licensing arrangements?
I would have to revert and get back to you.
Thank you very much. Member Ramkisoon.
Thank you, Mr. Chair, and I know that time is against our committee at this time, but I do want to ask about the corporate entities account holders. And that is based on the fact that when we enter businesses, we hook up to their Wi-Fi and we access it. So I have two questions for that. Does Digicel or TSTT provide any limitations to these corporate entities in terms of their contractual agreements? And the second part is, does Digicel sell IP addresses, meaning that they're reserved IP addresses for businesses, as in fixed IP addresses, so they might purchase a block, so that way we know that block A is delegated to a certain business?
Okay, so that was a two-part question. I'd answer the second question. I'm not aware that we sell IP addresses, but I can revert to that department and get back to you with a written submission. And can you repeat the first question for me?
Contracting side of it, similar to the question I asked a little bit earlier, not as it relates to indemnity, but on the contracting side with your corporate clients, the scope of that contract.
What exactly would you...
So I'm thinking along the line that, well, from your submission, you indicated that it will affect, you would be affected by this bill in terms of your customer base. And then you went on to say that you are unable to identify specific account holders because of your corporate enterprises that may hold multiple account users under one particular account. And that's where I'm trying to get at. What limitations or what provisions do you have for your corporate enterprises or your major, for example, use hotels? What do you have for hotels then? What can you tell the committee that you have set up to say that the hotel can only do X in terms of providing internet access to guests or to people who just step in, that sort of thing?
Well, I'm not aware of any specific limitations. I would have to double check and get back to that question. But it would depend on the type of package that the corporate holder takes, because if the business is small, they might not need as much capacity as a hotel. They might take a different type of product. So the limitation might be on the type of package. So I'd have to revert and get back to you in terms of those specific limitations.
Mr. Chair, I would like that in writing, though, in terms of when they're making their submission, the different types of limitations that they have within their system right now, and we can see how it can tie into the law that we have here, right? So thank you.
Before I invite broadening of positions, could I just, in terms of apportionment of time, look towards TSTT's side of the room for a moment? Ms. Coombs, may I please ask that relative to your submission as to the extent of criminalization, the sanctions, you made a general submission that you considered, forgive me for paraphrasing, that there was an excessive form of criminalization, meaning the sanctions were very high. I'd be very grateful in your further submissions if you could identify which of the sanctions you considered to be disproportionate and what recommendations you may have in respect of that treatment. If you wish to disaggregate between summary and indictable, hybrid, do you wish a lesser form of penalty? Is it just the monetary side of the sanction, or is it the term of imprisonment aspects of it? Whether you are contemplating strict or other forms of liability in your consideration of the fines and penalties. Thank you for being very concise and cooperative. If we could just invite TSTT. TSTT has provided us with a written submission as well. May I open the floor to TSTT for an opening statement if they wish to have one, and then to conduct a similar exercise to the one that we've just done with Digicel. And thank you, Digicel, for breaking the ice and being the entity that went first. Please, Mr. Carter.
Yes. Mr. Chairman, thank you. And I think given the comments made by Member Clarence Rambarat, I do believe an opening statement is necessary. So, thank you, Mr. Chairman and members of the Joint Select Committee, other operators, ministry officials in attendance, support staff of Parliament, members of public, and the online viewing public. I bring very warm greetings on behalf of the board and management of TSTT. And I also extend most sincere apologies on behalf of Dr. Ronald Walcott, who had to attend to a personal emergency this morning, so he was unable to attend this sitting. As an internet service provider, TSTT welcomes the Cybercrime Bill as a means of governing the obligations of businesses like itself, whose purpose is to make the internet available to its customers. TSTT wishes to confirm its support in principle for the provisions of this bill. As a company, TSTT continues to utilize all means of detection of unlawful activities occurring on and/or affecting its network within the ambit of current legislation. We recognize that historically, the fight against cybercrime in particular has lacked the tools of criminalization of certain nefarious online activities and the mechanism of appropriate deterrence. Simply put, the fight against cybercrime requires a combined effort of both technological advancements and legislative measures. I am certain we can all recognize that over time, there has been a shift in what we value as humans. From physical property to our intellectual property, our personal information, and our privacy. It is in this regard that TSTT feels duty-bound to express some reservations in relation to the current requirements of ISPs under the bill. As would be noted from our submission to the Joint Select Committee dated June 23, 2018, and from further submissions, which we would like to raise today, the obligations of an ISP in relation to cybercrime as currently encompassed in the bill are not always clear, and in some cases unnecessarily opaque. It is important that the uncertainties be sufficiently ventilated in order to be clarified, as the potential impact on ISPs and their customers is great. Mr. Chairman, with your permission, we can do one of two things now. We can either rehash what we in fact submitted before and expand on it with some additional comments we would like to make, or we can simply await questions from members.
Benefit of having received and read your submissions, which are very clearly set out, and I thank you for them. The committee was very ably assisted by your observations. Perhaps it may be that we could open the floor to you to amplify those submissions which you think you may not have had a fulsome run at. Could we perhaps do that first and then open the floor to questions?
Right, much obliged.
Chairman, and if you could, Mr. Carter, I mean, based on, and I know you're competitors, but you have similar operations in terms of standards, would you be able to answer some of those questions that would have been asked before in terms of the basic information that Digicel has promised to get back to us on regarding the IT side of it and the information that will be captured from account or non-account holders that access your service from your company's perspective, because you may have those answers and they may be comparable to your competitors?
I feel reasonably assured that we can answer all the questions
Thank you so much. Appreciate that.
Today. So I will now turn it over to my colleague, Mrs. Solomon, and she will continue to amplify some of those concerns that we did not address before.
Good morning, Chairman and members of the committee. Thank you again for the opportunity to be here. It's much appreciated. As you would have before you, I think it was 8 points which TSTT would have raised in our submissions. What I really propose to do is to touch on a few of them that I think perhaps bear further ventilation. And I will start, with your permission, Mr. Chairman, with Section 23. We did have a discussion with Digicel earlier on in terms of the requirement under this section to disable or remove access to information, and that is the requirement of the internet service provider to do so. In our submission, we would have indicated that our concern there was that it may not always be the case that the information which is required to be disabled is entirely offensive against the provisions of the Act. I think, for example, of requiring an ISP to disable access to a particular website or access to some information which may in and of itself contravene the act, but perhaps there are other members of the public who have a right to access that information because not all of it offends against the act. And so our concern there was whether in circumstances where an ISP is compelled to disable access, there could be any provision for an ISP to be heard. I think my friend at Digicel also touched on it, whether an ISP could also be heard on the subject matter. I want to draw a slight parallel here to the position in relation to internet service providers in the United Kingdom, particularly with regard to copyright infringement over the internet. The law in the UK has developed in such a way that internet service providers and persons whose rights have been infringed by an offending website that may be streaming a film that's subject to copyright and that kind of thing, the law is developed in such a way where the rights holder and the ISP, even before going to court, actually meet and agree to the terms of the requirement to disable access. So it may be that full access is not disabled in the interest of the public also being able to access information. And it was just a suggestion of TSTTs that perhaps this could be considered in light of Section 23 as it's currently worded.
The limitation on access.
I would say
to
so.
preserve that which is non-offensive as distinct from that which is offensive.
That is also.
And whether it is technically even capable. And therefore you're suggesting that that could be assisted by a hearing where your views on the sensibility of the order can be factored. Is that correct?
That is accurate. And just to even enlarge on that slightly, at the end of the day, an internet service provider is running a business presumably for profit at some point.
I like that word, presumably.
And in so doing, I think this whole question of internet service providers in relation to cybercrime and any crimes really committed over the internet or through the use of a computer is that whole question of balancing the public interest in free and unfettered access to information, their interest in having their own personal data protected, and the right of the state, obviously, to pursue crimes committed over the internet and the importance of that. It is such a balancing exercise.
Your submission is clear. I understand you perfectly well. If I could be so bold as to interrupt you on that.
Sure.
May I invite you to proceed with your other submissions?
Not a problem. With respect to, I won't touch on Section 24B too much. I will.
I'd be grateful if you could clarify the reputational damage aspect of 24B.
So that again, which I just briefly mentioned just now, it's just in relation to the fact that our society is a small one. Again, I would like to draw a parallel to the Interception of Communications Act, to which TSTT is subject. We are required to provide information on occasion about subscribers to our services. And in the same light, Section 24B requires that we produce information about a person who subscribes. And I think the concern there was just, again, that whole balancing exercise, just making sure that in us complying with the provisions of the bill when it becomes law, that we do not create this impression that people's personal information is not safe within our organization.
Are you assisted by the provisions which follow Section 24, in particular Section 26, where the concept of confidentiality of the order and disclosure may be the balance that you're looking for?
Yes, and in fact, it was what what we considered in making the submission on 24B, the fact that there is this requirement for confidentiality. And I think the thinking was at the time that that provision requiring confidentiality perhaps would also work against the ISP in that we can't say, well, we're disclosing because we're required to, because this request was made. And so that the only thing the public may become aware of is the fact that information is being disclosed. And that is where, as I said, I'm trying to juggle the intent. I believe what the intent is and what the effect in reality may be.
Can you proceed?
Sure. In relation to Section 25, the preservation of computer data from loss or modification, again, very simple query, really, in terms of what, if all reasonable attempts are made, or I think it's our submission that all reasonable attempts should be made to preserve the data, but if, notwithstanding such attempts, the data is in fact lost, I just wondered whether there was any sanction or any penalty that would result.
So a careful balance to avoid the innocent infringer, the lack of recklessness, the lack of willful loss may suffice. In other words, then, if we qualify the mental intention of the offense by prescribing conditionalities for recklessness or willful position, would that, in your mind, be the balancing tool?
I believe it would.
Thank you.
Moving on. The disclosure of details of an order. And again, this is the confidentiality section. Our submission there really just relates, if I could sum it up, to the fact that under the Interception of Communications Act, there is this specific carve-out in relation to obtaining legal advice in relation to any order or notice which may be served, in the Interception of Communications Act, on an ISP that is required to produce call detail records.
The usual exceptions to confidentiality.
Yes, so that I just felt it interesting that it was specifically carved out in that legislation, whereas here it does say, intentionally and without lawful excuse or justification, which in itself may be sufficient. But I just thought we would draw it to the attention of the committee that perhaps a carve-out in relation to legal advice may be warranted.
Thank you.
I will not address the committee unless asked to on section 27. I think that was fairly straightforward. In relation to section 28 and the use of a remote forensic tool, I think, or at least the intent of that section is clear. The use of a tool by the police that would assist in obtaining the necessary data from a computer system is obviously what is required. I believe the thinking in looking at this section, though, was what exactly constitutes its support that the ISP is required to provide. So it simply says support the installation of the remote forensic tool. So I'm assuming that the police officers who will in fact be using the tools will be so trained in the use of the tools so as to extract the information. But I just wondered what support would be required. I think Digicel had a concern on the cost of such support, but
you cause it to be installed. In other words, then, that your own technicians and persons familiar with your software and hardware facilitated or caused the installation of the forensic tool.
And to respond to that, is it then the understanding that the installation of the tool will be done on our network, or is it with respect to a computer on which there is some data that needs to be extracted that will not necessarily be on our?
Perhaps involve both. From my work with the TTPS and Cybercrime unit in a previous incarnation, I can say that it in fact includes both opportunities. What I was trying to drive at, and correct me if I've missed the target, was your concern as to somebody who's unfamiliar with your system, your hardware, your software, entering and or having access to something which may cause a disaster for you in some form or fashion. So I was wondering whether you wanted to be the person that effected the access, the porting or the transmission tool, the forensic tool, or quote unquote just allow the third party, i.e. the police officer or person named by the court order, to do it. Was that part of the mischief you were concerned about?
Actually, you've been helpful. That enlarges, I think, what our original concern was. The concern was not so much what you've articulated. It was simply a matter of understanding what support was required. So now I think we understand better that that tool may in fact be used on our network, or it may not, or it may be a matter of both. And I think that consideration now will allow us to give some further consideration.
I can also add, with respect to the forensic tool, has a lot to do with confidentiality, a great deal, and that confidentiality is shared between both the ISP provider and the police, so that it's really held in strict confidence because of the nature of what is required. So that you determine who you want to interact with, the police as law enforcement personnel, and that's how it's done to a large extent. And it's overall the network, quite frankly, wherever it is required based on what is being pursued.
Mr. Carter?
Yes, thank you, Chair. Actually, our understanding of the use of the forensic tool was that it was going to be used by a third party, most likely the police officers. If in fact it is something, a responsibility that will be shared by TSTT, then we would certainly have to join with Digicel in raising the issue of cost. Because unlike the Interception of Communications Act, there is no cost to TSTT other than a human cost in terms of accessing the information. This would certainly be different. I just wanted to make that point.
Can I ask the same question I asked of Digicel, and I'll ask Member Mooney now to jump in right after, whether you have an indemnity provision in your contracts or your licensing arrangements with your users where you can recover the costs from the end user?
I am not aware of any such indemnity provisions.
I would assume that there are, so I'd ask you just to explore in similar fashion to Digicel, please.
We certainly will.
Member Munilal, I believe you wanted to ask a question. It's okay? Gail, can you continue with your...
Certainly. With respect to Section 33.2, which is very clear that subsection 1 in relation to an ISP that I would call a mere conduit, just simply providing a conduit for the transmission of information and so on. Subsection 2 indicates that that subsection does not relieve an ISP from complying with any court order, injunction, writ, or other legal requirement which obliges an ISP to terminate or prevent an infringement based on any written law. Again, I just wish to draw the parallel because much of the language in Part 4 of the bill, to my mind, is drawn from the e-commerce directive of the EU. And very rightly so. So that of the UK, right, understood. And so this subsection, I think the point that we wanted to make here is actually related back to that whole question of whether an ISP will ever have a chance to be heard. Because saying that there is compliance, that there must be compliance with any court order, injunction, writ, or other legal requirement in order to prevent an infringement based on any written law is a broad requirement to not allow such access. And in those circumstances, it goes back to the point that we were making earlier in relation to legitimately providing customers with service versus preventing cybercrime and assisting with the prevention of cybercrime. So the point there is really the same, that ISPs, I think, would like an opportunity to make submissions in order to narrow the ambit of any order which may be made against them. The last point which I'd like to raise, it was not specifically raised in item 8, although reference is made to it. I just wanted to touch on the language that is used on a couple of occasions in Part 4. And I'll just take the example of Clause 37(1), subsection B. The Internet service provider, upon obtaining knowledge or awareness by ways other than a lawful order from any appropriate authority, I really should have read the opening. An Internet service provider who enables the access to information provided by another person by providing an electronic hyperlink shall not be liable for information that is in contravention of this act if, and I'm back to subsection B, the Internet service provider, upon obtaining knowledge or awareness by ways other than a lawful order from any appropriate authority, expeditiously informs the authority to enable it to evaluate the nature of the information and, if necessary, issue an order to remove the content. Now, again, not specifically stated in our submission, but what I would like to raise at this juncture is really two things. We're a bit fearful of this particular subsection, I'll be honest with you, because of the way that knowledge or awareness is worded currently. It simply says, upon obtaining knowledge or awareness. And again, going back to just the e-commerce directive and all the member states of the EU who would have enacted legislation coming out of it, the big difference between the language that is used in the European legislation and in our bill is the omission of the word actual. And it is TSTT submission that the way that it is currently stated is very nebulous. And we believe could possibly lead to some misinterpretation or some unnecessary broadening of the requirement of an ISP to have this knowledge. I want to submit, or we would like to submit, that the requirement should instead be for actual knowledge. Now, again, to go back to the copyright legislation of the United Kingdom, an internet service provider is not liable for content which it provides access to once it has actual knowledge of an infringement. And it goes on, the subsection goes on to actually indicate that actual knowledge would involve circumstances perhaps where a notice was given to the internet service provider, sufficiently detailing the infringement that is being complained of. And to bring it to our circumstances, we're just a bit fearful that the broad ambit of this subsection in relation to knowledge or awareness could have the potential for some danger. And so our suggestion would be that we narrow it to actual knowledge.
Innocent infringer and also the EU actual knowledge platform. Is that correct?
We're very comfortable with it. We do think it is instructive in this situation because it will allow, we feel almost as though the way it's currently worded, it could almost result in a sort of a monitoring, which is the very thing that one of the previous subsections wanted to guard ISPs against.
So you don't want to be a data scrubber. You want to have, to put it for the average person listening, you want to have the ability, as Facebook does, to receive reports. There's a policy, you consider you've crossed a certain threshold of complaints, etc. So correct me if I'm not on the track that
you're on the very track that we would like to have recognized, yes.
I take it that Digicel shares the same issues that are raised here. Member Munilal?
To raise a matter here, and it's really not so much legal as it is a principle to debate. As to, and I'll say it in a layman language, there's a resistance for self-policing, that you prefer an external entity to police. Why is that? What is the principle behind that you are, I'm using the word resistant, but I don't mean it in a strong way. Is it a resource issue? Is it a technical issue? What damage would come to you if hypothetically there's a division in an ISP that monitors alleged infringements, as opposed to saying, look, let it be external to us. As a principle, why do you resist in that way?
Thank you. I'm not sure that I would agree with the use of the term resist, but I understand your point, certainly. And I think to answer your question, it is all of the above that you've raised in terms of is it a resource issue? It may just become one because nobody knows when this legislation is enacted. The volume, I mean, again, I can't help but go back to the Interception of Communications Act. There were very few requests at the beginning, and now requests are coming in. So it's a number of issues. But if I just go back, and it was actually going to be my second point in this subsection.
Sorry, my microphone keeps collapsing. I say I will include for you the subjectivity issue as to, how one determines what is offensive or not. But can I ask a question? Is that submission confined to HTML only?
That is not a question that I can answer, but I'm certain I can turn to my colleagues.
No, I will certainly ask the Chief Technical and Information Officer, Mr. Roger Richards, to answer that.
No, I would say.
Sorry, I should clarify for the public. I'm talking about hyperlinkage for general point. In other words, then there's that little blue material which is underlined. You touch it and you jump to someone else's site. You hypertext may link to that position. I have asked that because your submission starts off in an HTML context. So I wondered whether the scrubbing innocent infringer argument was confined only to the HTML issue.
My apologies, I misunderstood what you would have just asked. You're right, and that is why I said that we would not have elaborated, because I think I just made reference to the hyperlink, but the language was used in relation to, I think, hosting providers as well, which TSTT can fall easily under. So no, it's not just limited
Thank you.
to.
Okay, understood.
Thank you.
Just one bit of clarity from Mr. Carty. He promised earlier on to clarify questions asked by members Hines and Rambarath regarding the information that is generally captured under the legislative circumstances as a matter of protocol by TSTT, whether it's be an account user or someone using your internet service otherwise. General information that's usually captured by interface of your service provision.
So there are several parties involved in the type of information which you're referring to. In some instances, what we provide is the IP transport, and the customer user interface is equipment, policies, and software and services managed or governed by the particular entity. And as in the case of a corporation, they have an IT department that sets up access to their corporate network. They have policies that govern that, and they have information that they capture and manage with respect to password, security access, logon, and that type of information. And they are the owners, managers, and subscribers to that. And then what they get from us is a wide area or internet connectivity that transports them to other locations or the internet. In that particular instance, we could provide the information relative to the corporation and that transport which we provide, and any additional information relative to the particular use or IP addresses or devices would then be controlled by the systems of the corporation. In the case of a Wi-Fi access, such as Starbucks or something, it's a similar type situation, but perhaps less so, because they don't necessarily monitor, depending on their particular policies, the particular users and devices that access their system. But that system may store that information, which may be available for probing by authorities to get additional information there.
Layman's term, the information may be either reposed with TSTT or the secondary or tertiary entity.
Yes, that is correct.
Member Hines and then Member Munilal, please.
Thank you. Ms. Solomon, in respect of clause 37, particularly 37B, you did observe that the word actual was left out before the word knowledge. What does that word actual mean? What's the difference? And could you give an example of what you expect by application of the word actual?
Thank you. For me, just from a broad legal sense, obtaining knowledge and awareness as opposed to obtaining actual or having actual knowledge or awareness, the difference comes down to, in my view.
You want to avoid the constructive aspect, right? So the implication in law that you ought to constructively have been aware of a situation. So you want to have a proof positive of an actual position. Is that it?
That is it. And if I can just go back very briefly to Member Munilal's question in relation to why this resistance towards self-policing, I also wanted to bring up the point that the rest of the subsection, which states that by ways other than a lawful order, that particular phrase, I think, is I am certain I can guess at what the mischief is that it's trying to catch or to allow. And by allow, I mean, you know, in the context of an ISP acting to stop the cybercrime. But then it goes on to say, expeditiously inform the authority to enable the authority, as I think it rightly should be the one, to make the determination. Taking everything together, to come back to your question about this fear of self-policing, I think it's just that in this particular subsection, the way that it is worded, it would seem to have such broad application that I think an ISP would be somewhat fearful of not going far enough or maybe going too far.
Just a quick clarification. In your submission, you also made reference to Section 23, but I'm not sure if it's the exact position of Digicel earlier. Just for the record, the information that the bill requires is information that you would have access to, user information, at all material times. Do you keep user information as well? And how long after someone has exited your system, so to speak, do you maintain information on the user in the event that something like that is required for prosecution? I just wanted to get that.
Thank you. So I will ask Mr.
Digicel and to you, to perhaps provide that in a further submission.
Certainly.
So that you have better access to your data management policies and prescriptions.
Certainly.
We had interrupted you, Mrs. Solomon, at your last submission. Have we traversed that already, or did you want to say something further?
No, I think we've pretty much fully ventilated.
Then may I ask, sorry, that you also indicate in that further submission if you have any views with respect to perhaps a joinder of issue with Digicel on the criminality and whether it's excessive in your view or not, and how the mens rea ought to be treated if you have a view on that in the further submission that you may make to us?
Certainly, and we welcome the opportunity to make a further submission, actually, and in furtherance of Member Rambarat's point of looking at the rest of the Act and not just the ISP provisions, we would welcome the opportunity to do that and present further submissions.
Thank you very much.
Thank
Members, may I ask, well, first of all, may I express our profuse gratitude to both Digicel and to TSTT for giving us very fulsome assistance. You have been very gracious in answering all of our questions. We, of course, understand the need to come back with some further clarification, and we look forward to your further submissions. We propose to ask TATT to join us at the table to give some of its perspectives. They have had the benefit of hearing a lot of what we've asked this morning and some of what you presented, at least from the oral perspective. They may not have received your written submissions. That's why I say some. So I'd ask you if we could just press pause for a moment, invite TATT to the table. I'd ask you to stay because I'd like you to hear what they have to say. There may be some assistance to be provided in terms of clarification from the regulator's point of view insofar as TATT is there. So may we press pause for a few moments just to do some musical chairs? Thank you very much.
Thank you, Mr. Chairman.
We are recording, and introductions having been made on the part of the members of the committee, may I invite the members who are representing TATT this morning to introduce themselves for the purposes of the record.
Chief Executive Officer of Telecommunications Authority of Trinidad and Tobago.
And my name is Carol Douglas, Manager, Legal Affairs.
Thank you very much. We thank you, TATT, if we may call you that, for your written submission to the committee, June 14th, 2017. It was a general submission set out in 7 paragraphs across 2 pages. May we invite you to give us an opening statement if you have one, and to immediately follow into your presentation of issues which you wish to bring to our attention.
In large measure, the chairman, and members, good morning. In large measure, the bill speaks to the operations of our providers more than it speaks to the regulations that TATT would be required to, the regulations that TATT currently, based on its act, is required to maintain. And therefore, yes, there were 7 paragraphs across 2 pages because we would want to speak to things like the right to privacy and all of those things that you would have read about in this minimal submission. I noted that some of your questions this morning were technical in nature, and we did not, based on the information we came with, we didn't work with a technical person, but we will, in fact, attempt to answer any of the questions that you have as far as is possible. Because we felt it was largely legal, we've worked with Mr. Douglas, who will take most of your questions. I will assist as we go along.
Specifically, I'm very interested, beginning at paragraph 2 of the submission, to understand the parameters of the ISP's ability to manipulate, that is, to the state being granted the right to order an ISP to manipulate their operations to facilitate access. Perhaps you can begin there?
Thank you, Chairman. I will just go back a little bit to agree with the acting CEO in respect to our position, which essentially is that as a regulator of the telecommunications and broadcasting sectors, we really do not have any issue with the bill. The comments that were made, as a matter of fact, in respect of privacy and security and so forth, we would possibly want to have an opportunity to withdraw some of those comments. And I'll tell you why. Because we thought at the time, maybe from the review that was done at the time, there was a certain position. However, I think it would be useful to revisit that position. And on that basis, I would say we would welcome that opportunity to provide some clarification on what we have here before you. And specifically in respect to 3 and 5, which I would humbly request be withdrawn. Yeah.
One legal mind versus another, and also insofar as we've come a little bit further than that which you considered. So we welcome your further submissions, which can clarify your previous submission. Member Munilal.
Mr. Douglas, just to be absolutely clear, the document in our hand, June 14, 2017, you're saying that at this time you are not fully satisfied with the submission that was made to the committee, and you'd like an opportunity to send another submission to replace this?
Yes, please.
Okay. May I ask in your further submissions that you treat with the issue from a regulatory point of view of other forms of access which you can or cannot compel from a licensing perspective? That comes to life in particular in section 2, and in paragraph 2 of your submission, where you allude to the state being granted the right to order the ISP to manipulate operations. TATT, as we know, has a regulatory regime which involves a licensing arrangement, which has certain conditionalities, some of which may be managed from a practical point of view as it relates to the cybercrime aspects. May I also ask that you consider the existing law in that submission, which is your Computer Misuse Act. There may or may not be reflections in the Interception of Communication Act that can assist, and if you could perhaps treat with that as well. May I ask members of the committee to indicate if they have any other concerns that they wish to have addressed, or perhaps present direct questions, please? Dr.
Just to state for the record, and not only for this entity, but others as well, that I believe that the discussion that evolved in the committee would be legal, it would be technical, administrative, and so on. And in the future maybe a good composition that could help us quickly would also be welcome.
Some of the comments I do share, and I don't have a difficulty assisting the committee now in respect to certain parts, because we did indicate as far as the sanctions, we did share the view that we thought that there were somewhat, I don't want to say draconian, but the penalties, $1 million and $2 million. Now, even as a regulator, we do understand that we do have some small providers, and in respect to where penalties are of that nature, it may be, for want of a better word, maybe, I don't want to say a threat, but maybe an issue for providers. And of course, the general perception as far as privacy is concerned, well, as the chairman did note, we don't have to address that because we do understand, well, that is an issue, but the act or the bill does mention it is going to be a 3/5 majority, has a special majority. So we don't have to broach that issue.
We welcome your submissions on the excessive criminality perspective, which is something that both Digicel and TSTT have presented this morning, and we're wide open to your suggestions and recommendations. Is there any other matter that you think we ought to, having heard the submissions from TSTT and from Digicel this morning, and the inquiries on the part of members of the committee, if you feel that you wish to address any of those from another end of the equation, we of course also welcome that. Member Richards?
Just as an aside, well, not an aside, but because you're the regulatory authority in Trinidad and Tobago, just a quick assessment from you that if you, based on what I know has been happening behind the scenes for many years, where TATT is concerned with, in terms of a policy on spectrum and analyzing how spectrum will evolve in Trinidad and Tobago, is there any aspect of the bill that you think is not covered in terms of us looking ahead at this industry that you may want to include in your submissions? Because I know in TATT's deliberations, there has been quite a bit of discussion on the regulatory aspect and the spectrum, as it were, and how this may evolve in the future. And of course, this bill should take that into consideration, so we don't have to be reinventing the wheel down the road. And those could be included in your submissions for some assessment of the situation.
There's one final point that I'd like to raise, subject of course to all other members in indicating other concerns that they may have. If you think that there is a need for any consequential amendment to your own parent legislation as a result of this particular product, please feel free to indicate that, insofar as sometimes there is a need for harmonization as it relates in particular to the ISP provisions in the bill.
Yes, Chair. As a matter of fact, there are currently moves to amend the Act. So it would be timely to consider whether or not the Act should also consider this piece of legislation and whether there should be some harmonization or streamlining of the two so that at least there is some, so it's facilitated. I just wanted to go back to the member's question. I wasn't too sure in respect to the spectrum. So we will look at it, but I'm trying to understand, is it in respect to spectrum how we refer to the range of frequencies that a provider would use to provide a service?
And also, I understand there was some discussion on, and this would affect the ISPs in particular and those companies, the rationalization of the spectrum and the frequencies as they exist to make them more efficient. And I know that TATT has been looking at that assiduously. And some of the changes that are proposed or were proposed in the initial discussions may affect the ISP providers, and as such, how this bill impacts the operations.
Chair, we will take a look and provide some information. There was one other point which, Chair, you did raise in respect to the submissions from the previous witnesses, Digicel and TSTT, in respect to how long data is retained. And we did take a quick look at the concession document, and the concession document does provide under C13, I think it is, and D, I'll just get to the exact provision, without reading out the entire provision, but it does set out time frames for how long the providers or the concessionaires are to maintain data. And in the first instance,
C13, it's short, so I could perhaps read it. The concessionaire shall keep for a period of at least 1 year records from any metering or billing equipment and related customer data, and shall provide to the authority in such a form as the authority may reasonably specify copies of such records. The foregoing shall not apply to accounting records, including copies of all customer bills issued by the concessionaire, which shall be kept for a period of at least 4 years.
yeah.
Chair, thank you. In your submission, number 4, you made a comment about section 22, which in relation to a warrant. But it is written in the clause, so is there something else that you wanted included in section 22 in your submission?
All right. So that's one of the submissions we would like to withdraw, and we would like to come back and we'll provide more information if required, please.
Thank you very much, Member Marks.
Yes, sir. I'll be guided by the committee. If the committee requires it expeditiously, I'll certainly have it within.
Well, one of the benefits of having asked our previous contributors to stay in the room is that we can perhaps answer that question in the round. We, of course, don't want to do injustice to the quality of your submissions, but we think that you can perhaps clarify your further submissions. Is a week sufficient for you?
A week would be sufficient.
Yes? If, of course, you can't make within the week, if you could indicate your position, provide what you can, and then move further. The work of the committee really involves taking your submissions and putting them against a matrix of all submissions on similar clauses, and then the committee considers it in the round because there's several other submissions that we've received. So we would appreciate your contributions to come within the week. From now, we'll ask the secretary to write to you to provide, and we'll provide that information to you, but we can indicate that now.
Conscious of the fact that we have a very short week ahead of us, you're taking that into account?
Yes, I'm. Maybe if you'll be so kind, and allow me until maybe Friday, today being
Let's
Thursday.
go to Monday, the 9th of April.
I'll be grateful.
That would allow you the staccato in the week and give some of you the lives that you don't have otherwise.
Greatly appreciated.
Which join with ours. Members, we have a sitting of the House, of the Senate very shortly, and therefore we are obliged to bring conclusion to this morning's proceedings, now this afternoon's proceedings. Again, may I express my gratitude on behalf of all members for your assistance this morning. We will be broadcasting this at a later date, and we are certain that the population thanks you for your contributions this morning. May we press pause for a moment to allow you to leave and for us to just do a quick wrap-up on an in-camera basis. Thank you very much.